Yeah.
Okay. I want to wish you a good afternoon and to welcome you to today's webinar. It is inspired by the Nigeria VP and so this is the Nigeria versus PNID arbitration, and it's a case analysis. And we want to see the lessons that can be learned from for investors and host states. We are very privileged today to have a very international panel with us, and we'll be hearing from their perspectives from, of course, we're here in East Africa, most of us. We have panelists from West Africa and Southern Africa. Allow me to let you know a little bit about them. I know pretty much all of them probably don't need that much of an introduction, for they are well known to us, but it's always good to acknowledge the very weight of the experts that we have before us and their willingness to share the benefit of their experience and their knowledge on this issue, which is very cutting edge, very real, very live. And I'll start with Professor Gideon Muigai, whom we all know very well. He is a professor of public law at the University of Nairobi. He's a senior partner in the firm of Mohammed Muigai LLP. He is the vice president of the London Court of International Arbitration, African Users Council, and the vice chair of the United Nations Working Group in relation to human rights and transnational corporations and other business enterprises. He has taught me, so I've been his teacher actually for pretty much the 30 years that he has been teaching. And as an academic, he is extremely well acknowledged as an expert in public law, constitutional law, jurisprudence, litigation, and comparative constitutionalism. Like I said, he has taught many of us at the undergraduate all the way up to postgraduate level. And he has taught us constitutional law, comparative constitutional law, jurisprudence, legal theory, public international law, and international human rights law. For me, he taught me professional ethics. So, and I'm glad to say that he will be speaking about professional ethics on the international arbitration plane. So his international and domestic experience in dispute resolution cannot be gainsaid, because he has also been the Attorney General. And whilst he was Attorney General, he appeared before the International Criminal Court. He also managed to handle a number of cases before ICSID. He is currently a member of the Permanent Court of Arbitration at The Hague, and he has appeared in numerous cases of political and legal jurisprudence before a Supreme Court in Kenya, in Uganda, and many other parts of the region. So like I said, he was a chief legal advisor to the government of Kenya for almost 7 or 8 years, from 2011 to 2018. He was part of the team that drew up the Kenyan Constitution. He has been a judge in the African Court of Human and People's Rights, and he has been a special rapporteur in so many different spaces. He is a member of very many professional memberships. That is going to be our first speaker. Allow me also to introduce a good friend, Mrs. Funke Adekoya, a senior advocate of Nigeria. She practices as an independent arbitrator and litigator in Lagos, Nigeria. She was one of the senior members of, I think it's called, how you pronounce it, Alex? I think you'll correct me if I'm wrong, where she co-founded that firm. So she has been a lead arbitration counsel. She has been an arbitrator. She is a chartered arbitrator with CIR in Nigeria. I think in Nigeria, they say CIR UK Nigeria branch. And she is a governing member of the International Council for Commercial Arbitration. She's a court member of the Singapore International Arbitration Center, SIAC, and she has recently been appointed as a member of the expert committee of the China International Commercial Court. And she's ranked in GAR Chambers Global Who's Who Legal. She is a thought leader in arbitration and listed in Mute of Thursday's Compendium of Unicorns, Global Guide to Women Arbitrators. She has been listed on the chairman's panel of arbitrators at ICSID and very, very many other panels of international arbitration institutions. She has sat in on arbitrations in LCIA, ICC, ICSID, and she has also done ad hoc arbitration proceedings under UNCITRAL model rules, and her niche is energy and construction disputes, and she is also engaged in other commercial and investment-based disputes. And she has been awarded severally as the Arbitrator ADR Practitioner of the Year Award from the African Arbitration Association in 2022, and is listed in the Africa Arbitration Academy on the 20 arbitration par list of 2022 as well. And she's established to celebrate the achievements of leading African arbitration practitioners, to recognize their contributions to the development of arbitration in the continent. She is, other than being qualified in Nigeria, a solicitor, non-practicing in England and Wales. So you can already see that our panelists have a rich history and background on the international plane. Allow me to also introduce to you Jonathan Ripley Evans. He is a partner at Herbert Smith Freehills, and he heads up the South African dispute practice. He has a lot of experience in ADR and general commercial litigations on the international plane. He acts as a mediator. He is an advisor and representative in both mediations and arbitrations, both domestic and international. His practice is geared towards ADR, and he specializes particularly in commercial disputes in a wide range of sectors, including energy, mining, tourism, hospitality, property, construction, and engineering. Jonathan is one of us as well. He is a fellow of the Chartered Institute of Arbitrators. He sits as vice president of the AFSA International Court, and he is a core member in the drafting committee responsible for the revision of the AFSA International Commercial Arbitration Rules, which was launched in 2021. He is accredited in AFSA as a mediator and an arbitrator, and he is a part of the management committee of AFSA. He's also a member of the court, the Lagos Chamber of Commerce, and International Arbitration Center. Sorry, that's LASIAC. I think that's the name we typically know it by. And finally, we have our very own Dr. Wilfred Mutubwa. He is a chartered arbitrator. He is a fellow of the Chartered Institute of Arbitrators. He was the chairman, CIR Kenya branch immediately before me, and he has been an advocate of the High Court, and he holds LLB, LLM degrees, and a PhD, I beg your pardon, LLD, focusing on international economic law from the University of South Africa. His key areas of research include trade and investment dispute resolution systems in African regionalism and integration efforts. He also holds a postgraduate diploma in arbitration and international arbitration from the from the Africa Arbitration Academy. He is an accredited CIR by CIR UK. He is on the Potter-Next mediation program. He's actually one of the founding members, I think number 12. And he runs Dr. Mutubwa Law and Advocates. He also is a serious academic and is the Dean of Mount Kenya University School of Law. and he has been teaching at CIAP, at RIARA, and he is also one of the members of the Permanent Court of Arbitration in The Hague. So he is listed with the LCIA, that's the London Court of International Arbitration, the Mauritius International Arbitration Center, the Nairobi Center for International Arbitration, the Kigali International Center for International Arbitrator, and the African Arbitration Association, where he sits on all the panels. I think I should have just said he's an international arbitrator with many footprints in Africa. And he's done very many things also on the local plane. This is within our domestic area with the Political Parties Dispute Tribunal. And he has been awarded by the President the Order of the Grand Warrior of the Republic of Kenya. So he has been recognized severally, and he is also the 2023 Africa Arbitration, the African Arbitrator of the Year Award 2023 from the Africa Arbitration Association. These awards were just held recently in South Africa, Cape Town. Now, if you thought that the descriptions of the panelists that we have today was a bit of a mouthful, allow me also to just say one or two words about Nigeria versus P and ID. I can see we are still welcoming a few members. Please feel most welcome to today's webinar, which promises to be an exciting intellectual experience, and we will be able to explore what I think some people are calling it groundbreaking. I think the proper term, the way to probably conceptualize this new judgment is that it is an explosive judgment coming out of the English High Court. And it's one of the few cases that in the recent past have highlighted very difficult issues around the question of arbitration, the question of international investment deals, and especially within the context of where corruption has been alleged. So in a nutshell, I think we can trace the deal between Nigeria and PNID to about 2010. And this PNID is actually an offshore company owned by two Irish businessmen. And they also had various contracts in Nigeria. But this particular company did not have any track record in oil and gas. That notwithstanding, they were awarded the right to process billions of dollars in natural gas in Nigeria. And sometimes around 2012, they brought an arbitration against Nigeria, apparently for failing to provide promised infrastructure and gas. And the outcome or the output of that particular arbitration was that in 2017, PNID was awarded 6.6 billion in damages plus interest at 7%. Now that's an astronomical figure as it was then. But when the new government came into office in 2015, Nigeria felt that this deal was procured by corruption, that it had been fixed, and there was an element of bribing Nigeria's lawyers. So basically what happened is after the award came in 2017, Nigeria challenged the award, and it came before the Honorable Mr. Justice Knowles, and he's heard the case and he delivered his judgment. And essentially what he did say was that that original contract was obtained or procured through bribery. So he has quashed the decision, and the practical outcome is that what would have been an award in the amount of about 11 billion plus interest has now been put to bed. And Nigerian taxpayers can be pleased that they will not have to pay to PNID, the $11 billion. The $11 billion has been assessed at probably a third of Nigeria's foreign reserves. So you can imagine just what a huge saving that is. So many issues have arisen. Of course, there were many limbs of arguments that had been brought forth. And what we are going to do today is that we will look at just some of the things and the issues that could possibly be of interest, not only to Nigerians in general, but to Africans, in Nigerians in particular, but Africans in general as well. So we will be hoping, and I'm hoping to give each of the panelists an opportunity to speak for about 20 minutes. And I'll just probably highlight that Professor Gidum Wigai will speak on professional ethics, international arbitration. Mrs. Funke Adekoya will speak on cross-examination of expert evidence. And then Mr. Jonathan Ripley Evans will speak to us on discovery, privilege, and dishonesty. And Dr. Wilfred Mutuba will then speak to us on investments, investment decisions in investor-state dispute resolution. Now, I think it is possible to say without any expectation of contradiction that we will not be able to exhaust the issues that have arisen. But I do believe that this is a good standing point, and that we will be hearing not only from common law countries, that is from West Africa and East Africa, but Jonathan Ripley can also give us a good feel of what the Roman Dutch system, or civil, we call them civil systems in South Africa, how we can expect to hear from or expect the decision or the perspectives that we can expect to come from that jurisdiction. So without further ado, allow me to welcome our first speaker of the day, a very good professor, former Attorney General, chartered arbitrator, Professor Gibu Mugai.
Thank you very much, Madam President. I would try to be as brief as I can, but since I have 20 minutes, please grant me the permission to raise other issues other than the issues of ethics.
You're most welcome.
And I'll be very, very brief. For me, the first thing that I took out of this judgment was a matter that I have been concerned about for a long time. The preparedness of sovereign states to engage with international justice processes. And in particular, the preparedness of capital receiving states to engage with international investor arbitrations. I have seen it in my own personal experience when I served as attorney, the difficulty of getting a coordination between the ministry that initially contracted or which was responsible for the sovereign state contracting, and the Ministry of Justice or the Attorney's Office, as the case may be. And in this case, Nigeria's case is a textbook case of what not to do. I think Nigeria, notwithstanding the outcome of the judgment, the recklessness, the sheer recklessness with which the public officials handled A, the contracting process, and B, the dispute resolution process should teach us something. And maybe when we do the Q&A, we will talk about how to enhance capacity within governments to deal with such matters. That's one of the things that I took away. Secondly, I took away what you wanted me to talk about. how do we ensure the integrity of international dispute resolution mechanisms? Now, this debate has been going on for a very long time. If you look at this tribunal, the tribunal that made this decision, it is as distinguished as any in the world. So that you cannot say that on the face of it, one would have been concerned about the problem of ethics within the tribunal itself. But it is quite clear that in terms of counsel appearing before the tribunal, we appear to have no mechanism for accountability, for requiring disclosure of possible conflicts. And this is a real serious problem, in my view, going forward. And we can discuss that in the Q&A. How do we ensure an ethical framework within which we conduct international commercial arbitration? The third issue, which I took away from this judgment, relates also to a very old issue, a matter that we've been debating as arbitrators for several years: court intervention. Most of us, almost by rule of thumb, we are against court intervention. We think courts usually come to interfere with the arbitral process, and therefore to remove finality, to remove expeditiousness, and so on. Now, this case has reopened that debate completely and totally. It is possible now to argue that there exist instances where court intervention is what would deliver justice. And in this case, my own take is that had the court not intervened, a grave injustice would have occurred. The issue of bribery goes to the question of ethics, so I will not repeat myself on that. But I would like to say something about the question of the lack of transparency in arbitrations of this nature. I think that's a very vexing question, and we ought to spend part of this afternoon talking about it, because it is quite clear that more could have been done to call for accountability all around, and it wasn't. The second final point I want to make, you see, I'll be donating some of my time to the other speakers. Mm-hmm. The second final point I want to make is about, and something we have been debating for a long time. It is how you get a good representation before a tribunal. I myself have found that bringing in internationally experienced counsel to work with experienced local counsel is beneficial. And I think when I look at how Nigeria was represented at the tribunal and how it was represented in the High Court, you can see that it could have benefited from a hybrid representation before the tribunal. And I think Nigeria was greatly let down, and we can debate whether by collusion or otherwise. It was greatly let down by the level of professional engagement that was manifested before the tribunal. And I think that's a very, very serious matter. And now my last point relates to The judge, Knowles J., raises a fundamental issue that is very important to us as arbitrators. He, as I understand it, seems to say that in his opinion, there are some cases, like the one he had here, that are not suitable for arbitration. That should concern us very, very, very much. If we as an arbitration community were to lose the confidence of the legal community, whether judges or lawyers, we should be very concerned. And I think for me, I took away that as one of the conversations that we must continue to have domestically, within domestic arbitrations, and internationally. I will stop there for now, Madam Chair. How many minutes have I used?
Actually, you've just managed to do about 10, so that is quite.
So I will come back again for another round when my colleagues have spoken.
Okay. Yes, so just in the event that you are not able to read the chat, there's Isaac Alwachir who says that, and I think he's responding to or reacting to the point about the transparency or the lack of transparency in international arbitration. And his proposal is, how about sacrificing confidentiality in international arbitration in favor of public access in the same, especially for public interest disputes such as investor-state disputes. So please just make a note of that particular point that has been raised by one of our audience, and you can probably either agree with Al-Wachir, or you can distinguish, or you can just let us know what your thoughts are. So, well, and of course, this builds on the question of whether some of these cases are suitable for arbitration or not. And thank you for all the other points that you have raised about examining the contracting process and also the dispute resolution process. Looking at the integrity of international dispute resolution by both council and also the tribunal, and also to probably rethink the ethical framework and the question of court intervention. Are we ceding ground to court intervention? Of course, we all tend to veer towards the thinking or the school of thought that there should be as limited court intervention as possible. But then I think this case underscores the need to have that intervention. So, and also the point about local and international counsel. I know the other speakers are probably also chomping at the bit to build on what you have said. But since you've given me a little bit of time, I will also take the benefit to, first of all, acknowledge the presence of our CIAB Africa trustee, Dr. Chikwendu Madumere. He is present on the call, and I don't know whether you're there, trustee. Just give a wave so that everybody can recognize that you are with us.
Madam Chair, thank you very much. Thank you very much. Good afternoon, everyone.
Good afternoon. Good afternoon to you too. We are also joined by our Vice Chairman, Dr. Wayne Mutuma. I don't know whether he can see us. Please wave. He's actually our host today, and I may have overstepped. He should have spoken first before me, but karibu sana, Dr. Wayne. And we also have a few members of the board. I can easily see you as Nyaga Kithinji and Ibrahim Kito. And we also have the chair of our Uganda chapter, David Kagwa. They are all present with us, and I'm sure that when we get to the plenary, we'll also hear whether they have questions for this particular panel. Mrs. Funke, SAN, I know I picked up something when I was in Nigeria. You call yourselves Learned Silk. Yes, so you're up next, and I want to welcome you to also let us hear from you as well. Welcome.
Thank you very much. And as is the usual practice, but I really do mean it. I really appreciate CIAB Kenya for the opportunity to participate to this discussion as the only Nigerian on the panel speaking about a case, an arbitration that has shaken the arbitration community and given us all thought for deep reflection. And Professor Gitu Mugai, whose footsteps in international arbitration are clear for anyone to see, has highlighted some of the issues that are of personal concern to me, although that is not the purpose of my talk today. I do have a PowerPoint presentation. I have sent it to Evelyn. I don't know whether she can display it, or if I'm given screen sharing opportunities, I will then display it.
Evening. Can you please put up Mrs. Funke's presentation or give her sharing rights? Shabbat too, if you're available, one of the two of you kindly let us do so. But you can share. I think it says multiple participants can share. So just give it a shot, Mrs. Funke. Oh,
Okay.
there it is.
Well, okay.
Okay, there we go.
Okay.
Great, thanks. Yeah.
Okay, can you put it on the, thank you. Can you put it on the screen,
Slideshow.
the slideshow? Yeah, and start from the first slide.
Just go to slideshow. Yeah. And then you can say from from current slide, the beginning. From
Yeah.
current, yeah, from the beginning or current, yeah, either one will work.
Yeah.
Okay,
Okay.
Mrs. Funke, there you go.
Okay, thank you very much. I note that I have 20 minutes. I may want to claim some of the time that Professor Gitu has not used, but I hope that I will be able to stick to time. So the first screen just says who I am, where we are, what today's talk is about. It is the PNID court decision, lessons to be learned. And today is the 1st of December. So now that we are oriented, I am going to be discussing from the perspective of lessons for investors and host states. I'll be discussing the cross-examination of expert witness or expert evidence. So the framework for that discussion, can we go back a bit? Previous slide, please. The framework for that discussion is for us to start with what is the role of an expert witness? And essentially, an expert witness, in my view, has three important things to do, especially in investment state disputes or investor claims generally. The first thing is, if you are the experts proposing to assist the claimant in recovering the damages claimed, the first role of the expert is to review the basis for the claim. And I say this now, speaking from the perspective of an arbitrator who was privileged to sit on a dispute between an investor and a state, in which the investor brought its claim on the basis of a BIT, and the respondent defended the claim on the basis of a commercial dispute. And the reason why I say that this is important is because the time of the breach, from which date damages should run, was an issue. The claimant was claiming from the time in which they invested under the BIT in the country. The respondent state was defending from the dates from which they became a party to the investment. And there were many years of difference and much funds that had been involved. So the first role for the claimant, if you have an expert, is review the basis from the claim. When does your claim arise? How does it arise? And obviously, that would assist you in putting your claim forward. Now, if you are appearing for the defendant, or you're preparing expert opinions or expert evidence for the defendant, your role is actually to provide an input in drafting the defense, which also means that you must be conversant as the expert witness with the claim, with the basis of the claim, and together with counsel, be able to advise on how to defend that claim. If you're a quantum witness, then for the claimant, you must provide the basis for the damages claim. And in many instances, we're used to seeing quantum witnesses or quantum evidence being provided for a claimant in support of a claim. If you are the quantum witness or the quantum expert for the defense, which is something that in investor-state disputes in African countries, I am yet to see being fully utilized or properly utilized, then the role of a quantum expert for the defense is to provide an alternative and a more realistic measure of loss, and to counteract the basis for the calculations being put forward by the claimant. And in this respect, my favorite case is, I tell people, go and you read UCOS, the UCOS award, and look at the expert evidence provided by the shareholders of UCOS and the expert evidence provided by Russia, and see how they engaged, especially Russia, on the various categories or the various alternatives to calculating loss that UCOS put forward. And then finally, whether you are the expert witness for the claimant or you're the expert witness for the respondent, depending on what you are providing an expert opinion in respect of, you may be required to testify for the party who has appointed you at the tribunal if necessary. Obviously, if you are the expert witness on an issue of law, there may be no reason for you to be required to testify unless your position is materially different from an expert opinion in law being provided on the same point by the opposing side, in which case you would probably then be asked to testify. Can we go to the next slide, please? So now we're going to be talking about the types of expert evidence provided in the arbitration and the consequent litigation. I think you've gone ahead of me. Can you please go, can we go back?
Please, can we go back to slide number 4 now?
4.
Thank you.
Okay, and if we put it on the, yeah, thank you. So the type of expert witness evidence that was provided in the arbitration, in this particular case, PNID, and the consequent litigation. And now I will focus on what Justice Knowles actually said in the judgment. So anytime you see a number, it's a direct quotation from the judgment. So at paragraph 22 of the judgment, Justice Knowles said, the expert evidence was principally in the fields of chemical engineering, project finance, and Nigerian law. Can we go to the next slide? No, that's the previous one, the next one. Thank you. I would want to focus on the dramatis personae so that when we are reading the quotations from the judgment, because this is what I propose that we're going to do first before I comment, we'll understand who these people were. So the dramatis personae that are named in the judgment, Nigeria's expert, an expert opinion was provided by Upstream Commercial Advisory. They were a local Nigerian firm, and their expert witnesses was a Mr. Dari. On PNID side, their expert opinion was provided by Berkeley Research Group, and their expert witnesses was a Mr. Eid and a Mr. Wolf. So please keep those names in mind as we then move on to discuss the cross-examination of an expert witness. I'm reading now from the judgment. So the lapses in handling expert evidence. At paragraph 369, Justice No said, and that upstream, the government, that is Nigeria, the government's expert witness, quote, do not appear to have been shown Mr. Quinn's evidence. At 373, Justice No says, referring to the tribunal decision, the award, the majority observed that the upstream report contained, quote, no comments upon Mr. Wolf's contingency calculation, and quote, no comments upon the equipment which Mr. Wolf considered would be needed, or any specifics of his estimate. Nor was anything of the kind put to him in cross-examination, noted the majority, adding that, quote again, counsel for the government appeared to be satisfied with Mr. Wolf's admission that he had found the P&ID materials extremely helpful. Now we go to the next slide. At paragraph 375, still quoting from the arbitration award, Justice No said, turning to OPEX, the majority, that's the majority in the tribunal, the majority said that P&ID had made its own calculations of the OPEX for the project under 6 heads and arrived at a figure of $59,881,600. Mr. Wolf said, noted the majority, that he had reviewed these costs and considered that they were reasonably accurate. Mr. Wolf, said the majority, was not cross-examined on this part of his evidence. And the upstream report, quote, made no comments upon any of the 6 individual heads of expenditure, unquote. Justice Wolf goes on to say, one difficulty which the tribunal had with Nigerian submissions was that, quote, none of it was put to Mr. Wolf. Can we go to the next slide, please? Still notes from the judgment. At paragraph 379, Justice Wolf says, referring to the arbitration award, the majority observed that, quote, the upstream report offers no actual evidence of, 1, the incidence of militant attacks in the Calabar region and its effect on oil production. 2, if the attacks were against oil pipelines, how this would affect the production of associated gas at the wells. 3, whether there had been any interference with gas pipelines. Next slide, please. Next paragraph in the judgment, Justice No says, paragraph 380. P&ID's expert produced various references in support of the 93% figure and confirmed his belief that his uptime assumption of 93% was realistic. The majority noted that, quote, there was no attempt in cross-examination to discuss or challenge any of this information, unquote. In the very next paragraph, 381, Justice No says, the majority added, referring still to the award, quote, in any case, the upstream calculation is based upon a misapprehension evident throughout the report and the submissions on behalf of the government about the nature of the calculation which the tribunal has to make. It fails to appreciate that the calculation must be made on the assumption that the government will perform its obligations under the contract. Next slide. Can we move to the next slide, please? Still again, in the judgment on the failure to cross-examine the expert, Justice Knowles at paragraph 385, referring to the tribunal's decision, says, the majority observed that, quote, he, Mr. Eid, was not cross-examined on this estimate, save to secure the admission that forecasting oil prices 20 years ahead was difficult. And in the next paragraph, 386, the tribunal did not have the benefit of Mr. Eid's comments because none of this material, if such it was, had been put to him in cross-examination. Next slide, please. At paragraph 386 again of the judgment, Justice Knowles noted that when Mr. Dari gave oral evidence, he said that there were several forecasts available on websites, which were different from the new policies scenario. He did not, however, identify these or produce them to the tribunal. So this is what happens when there's an expert opinion and there's no evidence provided to support what is actually stated by the expert. So where does that take us? When experts do not engage. At paragraph 389 of Justice Knowles' judgment, he says, the majority concluded as follows, and these quotations are now from the award. Paragraph 101. Mr. Eid is an economist who has for 15 years specialized in energy markets. His evidence is that IEA's new policy scenario is the one most appropriate to be used in forecasting. None of this was challenged in cross-examination. 102. By contrast, Mr. Dari has said only that there are other forecasters in the business who have arrived at different but unspecified conclusions. No such forecasts were actually made available to the tribunal, still less to Mr. Eid. And at 103 of the award, the tribunal considers that there is no material upon which it can come to a conclusion different from that of Mr. Eid's second estimate, which gave effect to all the information presently available about the movement of oil prices. So that's what happens. When experts do not engage, the tribunal has only one expert opinion to listen to and to take on. So now let's come to the purpose of this discussion, the lessons that are to be learned. Preparation is key. Especially, and I speak from the perspective of African states that have become respondents in an increasing number of investor states disputes. Preparation is key. Professor Gitu, in his own presentation, has highlighted the lack of cooperation between counsel and government party and the amount of delays in preparing the defense and other things. And I think these are some of the things we may come to discuss later. But one of the highlights is, as government counsel, hiring external counsel or hiring an expert, you must understand your own case. You must understand the case that the claimant is putting to you. And you must ensure that your expert is appointed early, so he has an input into drafting what would be either the claim or the defense. In terms of host states and African states, your expert ought to have an input into drafting the defense so that you are actually engaging with the claimant on the basis of the claim even before expert evidence is provided and exchanged. If as a host state, the Ministry of Justice or the Ministry of Finance or the relevant ministry that is the party to the arbitration does not understand the case that is being put forward, it becomes difficult to adequately defend. There must be preparation to challenge factual assumptions on which an expert's witness conclusions are based. And so the second level of preparation is when you have actually received a, how would I put it? Is when you've actually received the expert opinion, whether it is an opinion on Nigerian law or any other law, or it is an expert opinion on any other matter, chemical engineering, or it's an expert opinion on damages. An expert opinion on damages will be based on actual calculations. The dates the breach of, the dates that particular events took place that the investor takes as evidence of expropriation or denial of rights or a breach of the principle that underpin an investor state claim. So unless at the beginning, defense counsel, host states counsel has not fully prepared, then firstly, the factual defense will be inadequate. And then when the expert opinion is provided, the ability to properly defend the factual assumptions may also be inadequate because they have not been looked at right at the beginning. So there are 2 points at which preparation is key. When you're drafting your defense as a host state, and when you are drafting the responsive expert opinion on behalf of the defense, you need to look at the factual assumptions and you need to propose counter assumptions that results in a different calculation. Your challenge to the expert damages report must be supported with authoritative and verifiable references. As we have seen from Justice Noel's judgment, he had made references to the fact that Nigeria's expert, I assume was a quantum or a damages expert, had made references to other oil prices available, but had not provided that information. And this is one of those things where preparation is key. But you can't prepare if you do not fully understand your case. And you cannot fully prepare if you do not appoint your relevant experts early. So let's now go to the next slide, please. The next lesson that I think we could learn from this decision is that you must cross-examine your expert witness. And you cannot cross-examine properly the opposing expert witness unless you understand the expert's report or opinion. So effective cross-examination of an expert witness depends on a careful analysis of the opposing expert's evidence, which is on the record. And now I will speak from my experience as arbitration counsel defending a claim, not an investment claim, but a claim for damages for breach of a commercial relationship. And the expert opinion that was provided, in fact, in the matter, there were 4 experts. Each party had 3 experts. And one of the experts had 4 expert opinions exchanged on both sides in respect of certain aspects of the claim. A fair amount of my time as lead counsel leading the team was, one, sitting with my client's experts, explaining to me what the other party's expert was trying to say, because it was a technical matter. And I'm a lawyer. You find out that being a lawyer, depending on the type of dispute you are engaged in, you will have, or you'll gain some elementary knowledge about various other things. But when it comes to things like spudding oil wells and drill bits, it became necessary to sit with my party's expert to explain to me the position that the opposing expert was trying to make in saying that a drill bit had not been properly aligned, and therefore this is what had happened, and this was the damage that had been caused, and their position. Now, if I didn't understand how drilling a well works in terms of oil rig drilling, I would have been unable to properly cross-examine that particular expert in respect of its expert's opinion with respect to drilling. There was also another expert who was brought to talk about grades of cement, and that the work that had been done was not in compliance with British standards, and the rate at which the cement cracked. And I spent hours having to sit with my party's expert, explaining to me how cement is tested for strength, so that I could understand the point that the claimant's expert was making as to whether the cement had been properly tested or not. So before you can cross-examine an expert witness as counsel, you must understand that expert's report, because effective cross-examination depends on an analysis of the opposing expert's opinion or evidence on record. And if you don't understand what his evidence is, you'll be unable to fully and properly cross-examine. Can we go to the next slide? And I'm getting close to the end. Now, when you get to damages or quantum experts, what are the lessons to be learned? Now, there's the same thing here. As arbitration counsel, I've had to sit with damages experts representing my clients, explaining to me in detail what the DCF factor is, how it works, and how changes in the assumptions upon which the DCF is calculated can impact on the amount of damages. Because that is the basis upon which, as counsel, you can then cross-examine a damages expert on the underlying assumptions upon which its DCF calculation, which is what most investors want to rely upon. And then, having understood that, and having liaised with the expert, as counsel, one of the lessons to be learned is the need to provide an alternative methodology in your own client's expert report. So, and then I go back again. For those who have interest, read the UCOS award. Lengthy, extremely lengthy, but it's full of information and learning. But in a nugget, if your client or if the investor, as is the one, is relying on a DCF calculation for damages, and as the state, you want to rely on sunk costs, you must not only criticize the DCF factor that the other party has put forward by challenging the underlying assumptions, but you must also indicate an alternative that the tribunal can look at. And if you're looking for sunk costs, then you must have the information as to what the sunk costs were and your calculations as to the damages that are claimable if the tribunal finds in your favor. Obviously, if there are other alternatives, competing markets, competing companies, comparable companies, analogies, then those are also things that as the party representing a state or a host state, you need to understand and be able to put forward. Because getting into the witness talks and under cross-examination, saying there are alternatives, there are other forecasts. If it hasn't been put into your expert opinion, then it really goes nowhere. Can we go to the next slide, please? No, the one before. Yes. Final lesson to be learned. I'm going to read a quotation from a friend and colleague that I think really sums up what we as counsel need to do. It's a statement by Juliet Blanche from Arbitration Chambers. It was published a while back on GAR. And she says, spend as much time as is necessary with your expert to master the technical issues, and then ensure your submissions explain the issues effectively and in sufficient depth. If calculations are included, ensure they are again as detailed as possible so that the tribunal can follow them and understand how to apply the formula used. If the tribunal doesn't understand the technical issues or understand how the quantum is calculated, then it can't give you the award you are seeking for your client. And I think, in essence, that summarizes what we as independent counsel or independent arbitrators are looking for. As an arbitrator, you are looking for counsel to tell you what is your claim or what is your defense, why we should not accept the expert evidence provided by the investor or the state, as the case may be, and what the alternative is and why we should accept that. And I'll give you one other personal experience in which I sat as arbitrator in a dispute involving an investor and a state, in which the investor had provided two alternatives. One was a calculation of its damages based on the DCF factor. And the second was a calculation of its damages based on sunk costs plus interest accruing. And when we went into tribunal discussions, I was able to persuade my fellow arbitrators that this was not a case that was suitable for the DCF factor, because it was a case in which the investment had not taken off, something similar to PNID. However, the calculations that the investor had produced, which was the sunk cost alternative and the interest that would have accrued, and we know that in African countries, our interest rates are high. At the end of the day, the interest that would have accrued on the sunk costs over the period of investment was probably 20 or 30 million less than the DCF factor. And so we were happy to proceed using the sunk costs basis. But from the perspective of the tribunal, you must provide an alternative to the position being put forward by the other side. And you must be able to explain why your alternative is the better solution. Can I come to the conclusion now? Investment disputes are usually technical. Counsel involved in defending such disputes must devote the time and resources required to provide a robust defense. And I say this because from my perspective, sitting as an arbitrator, I have found that counsel who are involved in making the claim on behalf of the investor do devote the time and the resources required to provide a very robust claim. However, when it comes to defending the claim, in many instances, the resources have not been fully committed, and the time required to defend have also not been put in. So state parties must be prepared to commit the financial resources required to defend investment claims. And they must do this by hiring their own experts early in the proceedings, even before a statement of defense is filed. Damages experts, petroleum experts, technical experts are not cheap. But when you look at the claim that is being made against the host state and weigh it against the cost of defending the claim, knowing that if you are successful in defending the claim, then you will most likely be able to recover all the costs you have expended in the proceedings. Then states who do not want to hire top quality financial experts, quantum experts, damages experts, top quality legal practitioners to defend these claims are penny wise and pound foolish. Thank you very much for your attention, and thank you once again for the invitation.
Thank you so much, Mrs. Funke. I really enjoyed listening to you. And I'm 100% sure that everybody has at least had one or two take-homes. And just in case there's anybody who is asking themselves, what is the DCF factor? I will invite Mrs. Funke to tell us.
Okay, I assume that anybody involved in the national investment, the DCF factor, it's actually discounted costs factor. Discounted cash flow. And it's a way of calculating the amount that the claimant would be entitled to over the period of the investment, if it had been allowed to progress, and then discounting it to present day values.
Yeah. Okay. So that's actually a very interesting area of engaging ourselves on, because the discounted cash flow, I think, tends to bring in the highest quantums on damages. So of course, most investors will adopt that formula. So it is good for us to familiarize ourselves with it so that we can be able to cross-examine the expert witnesses, because that is what they'll come up with. And like Mrs. Funke said, that in some of the cases, they'll give you an alternative, which may not be maybe a combination of other approaches. And I think the usual business valuation models tend to be either asset-based, income-based, or mixed, or there's a comparable with the market-based approach. So it's good to just keep that in mind, so that when you do come to examining or cross-examining the witnesses and putting them on the stand on their defense, you're able to challenge as far as possible what it is that they're presenting, so that it's not taken as gospel truth, especially given the figures and amounts that are usually in question. She did mention about the comparison of the basis, the BIT versus the commercial dispute approach, the question of when the time of the breaches. Those are important issues that somebody needs to keep in mind, because the breach is what now brings the formula into play, and you'll have a projection from there, there'll be a rate from there, there'll be the time from there, and then there'll be all the different analysis that you require to do that. I think that one just requires a webinar on its own, but the key thing is to know that these approaches are there. And also read, I'm good for the, I'm really happy about the reference to the UCAS award and how Russia was put onto its defense by UCAS. So I don't know whether there's anything else you want to speak to. One other thing I've seen with expert witnesses, and probably that someone would want to also think about, we have Mr. Dare, we have Ed and Wolf. It's good to also examine and challenge their background to see whether they are fit for purpose in your particular case. So have I left out anything that you said? Because all the things that you said are so weighty. I hope you'll allow us to share the presentation that you prepared, Mrs. Funke.
Please feel free to share the presentation. And I think that you have actually summarized all the points that I had made.
Yes, okay, that is great, yeah. So before I call on the next presenter, the next panelist, I've seen Chief Godwin Omoka. He's now Mr. President of the ICMC. Please feel most welcome. I have also seen a chairperson of the Nairobi Center for International Arbitration, my namesake and good friend, Jackie Oyuyo Kithinji. So please feel most welcome, and thank you for joining us in this very exciting, highly charged intellectual discussion that we are having this afternoon. So we're going to change gears right now, and we will be welcoming Mr. Jonathan Ripley Evans, a fellow member from South Africa, FCIAB, on discovery, privilege, and dishonesty. Also a very exciting area. Jonathan, over to you.
Jackie, thank you very much. I'm hoping that my camera is working. I can't see it now. I'm hoping that it's on wherever it is.
We can see you very nice,
okay.
very well, yes. Go ahead.
Okay, fantastic. Thank you very much for the invitation to speak. It truly is an honor to be in the presence of such distinguished practitioners in the field. And it is a pleasure to be here today. I think a little bit of background to me. Jackie, you already mentioned that I come from South Africa, and South Africa is a mixed legal system. It's one of the reasons why I've gravitated toward arbitration, because I often find myself in the gray area between the civil law and the common law systems. So our substantive law in South Africa really is primarily the Roman Dutch law, which is civil law, and our procedural law is largely common law based. And I mention this because I think it's quite important for this particular case, or analysis of this particular case. Reading the judgment, you get a clear sense that this is a word in favor of the common law system. There is a lot that is said that is very supportive of the principles that underpin the common law method for resolving disputes. And I am waiting for the opportunity to have a really robust debate with some of my civil law colleagues, because I suspect that their takeaways might be quite different to a pure common law lawyer's analysis of the judgment. And whilst I think we will all agree that a serious injustice was addressed, and this was a much needed decision of the court, there are some things that have sparked debates in the international community, which I'm very, very interested to see how they're going to play out. And one of them relates to documents, disclosure, because this played a central role in the reasoning of the court and the injustice that ultimately was determined to be present in this matter. This judgment has been described as being exceptional, and I think it's important that we appreciate that as well. This is not intended to open up floodgates. It's not intended to create causes of action under the English Arbitration Act and now start challenging awards willy-nilly. The Honourable Judge identified that the facts giving rise to this particular judgment were exceptional and in many respects quite bizarre and I think more bizarre that they actually came out. Unfortunately, corruption in the public sector is not as unusual as we would like it to be. It's a relatively common occurrence. And for that reason, the judgment like this is incredibly helpful for all of us operating in the arbitration space. Just a few remarks before I jump into the actual disclosure questions. And one of them from the first session that we heard today that I'd like to discuss quickly is the risk of regime change. When you're dealing with public bodies, there is always this concern that a deal that you strike with a particular government or government representatives may not be seen as favorable to the next people taking over. And I've seen it on numerous occasions here in South Africa where deals have been struck which appear above board. And after the fact, when there's a change of the guard, evidence emerges that there may have been some corrupt dealings behind the scenes. And not all of it involves corruption with the two contract counterparties. Some of it involves corruption internally within the government body, which places the third parties in a very, very difficult position. And our courts have on a number of occasions expressed the heightened duty of care imposed upon parties doing business with the state to check that everything is above board. It's unfortunate that we are there, that we cannot trust contract counterparties all the time, but there is this heightened duty. And that's relevant for what we're dealing with now, because in this particular instance, we did have corrupt or corruptee involved in the transaction, and that's why the injustice was properly addressed. But when we're dealing with public remedies in terms of South African law, at least, the primary focus of an administrative action or a judicial review is to reset the position. It is not to compensate parties. It is to make sure that neither of the two parties actually benefit. And one of the questions that popped up is, what about accountability for the state actors? So in this particular instance, we would have the third party, the payer of the bribes. Presumably, I think we can accept that they lost a lot of money in this endeavor. And rightly so, we would turn around and say, well, you paid bribes, you deserve to lose. But I'm not sure there was any accountability on the state side, where it appears as though there was also corruption. Most notably in this instance, to a much smaller degree, but we often see that there is quite a lot of money passing hands. And when we start delving into the arbitration space, we are moving outside of the realm of public remedies, equitable remedies, and the restoration of justice. We are looking at contractual breaches, essentially, and compensation for losses. So it's just one thing to bear in mind when we are operating in this gray area of private dispute resolution and arbitration with public bodies. And I'll touch on one positive development in South Africa in due course, which I don't think properly appreciated in the past, but this judgment has really, really highlighted that. But I'll get to that in a second. The other thing is, the first impression I got out of this judgment when I was reading it was, well, if this matter had been before a common law court, chances are this all would have come out in the wash in discovery. Now, maybe I'm a little bit cynical there, but I have seen in my jurisdiction where discovery through court process is very much the common law way of performing discovery. Show everything. Very broad requests, and you just have to show everything. But one thing I have learned in my career is that criminals are less likely to discover the evidence that is actually going to implicate them. And I suspect that this may have been the case. If this matter had appeared before the state courts as a court of first instance, discovery would have been performed. But I highly doubt that the bank statements evidencing the initial payments of the bribes would have been disclosed. And so I'm not entirely sure that the blanket statement that, well, this is a problem in arbitration, if it wasn't in arbitration, perhaps it wouldn't have happened. I'm not sure it's that simple. Yes, there is a much broader power given to a judge compared to an arbitrator in relation to discovery. But I don't think it's a simple answer. And we know that arbitration has been designed to try and streamline the process. And the biggest way to streamline an arbitration process that has traditionally been molded on the common law process is to reduce the phase of discovery, or document disclosure. And we do that in a number of ways. And the most common way we do it in arbitration, these days in my practice at least, is through red phone schedules, And that is bringing us a little bit closer to the civil law approach to document disclosure, where we ask people to disclose documents and then they hand them over. Now, the common law has been criticized for being a sanctioned fishing expedition, which, strictly speaking, it largely is, and we see it down here in South Africa as well. We often have parties who institute proceedings hoping to find evidence to justify a cause of action, where the civil law approach is a little bit different. They basically say, do your homework, get your ducks in a row. Once you have the evidence, then bring your proceedings. And we find ourselves in arbitration in the middle of that, trying to find a solution that satisfies both of there are more, but the two main systems of legal process, the civil and the common law. And, you know, we have the Prague rules on the one hand, which I feel go a little bit too far. We have IBA rules, we have procedural rules of institutions that seek to try and manage the process better. But at the end of the day, it's the arbitrator that makes the decision on what is to be disclosed and what is not to be disclosed. And the one thing that we have to bear in mind, and this is where I have a lot of sympathy for the tribunal in this particular matter, is the tribunal is bound by the reference to arbitration. They do not have an inherent power to expand the nature of the dispute that's before them. They do not have investigative powers. And so some of the commentary about this judgment was quite critical of the tribunal, in that the tribunal should have done more. The tribunal should have dug a bit deeper. But bear in mind, hindsight is perfect. And I think that is what we are seeing at the moment. And this judgment does apply a bit of hindsight to the facts at play. And I have sympathy for tribunal members that in the back of their minds have a concern that they may be taken on review. If they stray beyond the bounds of their reference to arbitration, they may be taken on review. Some words were mentioned in the judgment about how the tribunal could have protected a particular party a little bit better. We've heard about the challenges that the Nigerian team had. And I think that it's quite correct to say that the Nigerian team possibly let the Nigerian people down in the way that the matter had progressed. But state representation is complex, and I have sympathy for that. And the suggestion is perhaps that the tribunal should have been a bit more open to supporting one of the parties that appears to be struggling for whatever reason that may be. But that, of course, then opens the tribunal to criticism of lack of impartiality. And so there are all of these challenges, and I don't think it's as simple to say as the tribunal got it wrong. I think the tribunal determined the matter that was before it. The challenge that we had here is that it was a unique situation that required something else. And certain facts came to light at a later stage, which then highlighted potential deficiencies in the system. And I say potential because I don't think that the system is broken. One of the biggest problems here is that the proceedings were confidential. And this has been a debate that has been raging, particularly in the treaty space for a while, and the lack of transparency. If you're dealing with state actors that are themselves corrupt and a commercial party that is corrupt and they strike a corrupt deal and they get caught out and they get forced to initiate an arbitration, there may be motivation to try and settle on favorable terms to all parties, to the prejudice of the state concerned, which is obviously something that needs to be addressed. But I don't think that this is necessarily, that point is something that is unique to this case that we're dealing with right now. It's a much broader point, and it's something that we are applying our minds to. So just a little bit about disclosure in this particular matter. What was disclosed appeared to be sufficient for what was the case that was before the tribunal at that point in time. That tribunal had no real reason to expand the scope of discovery because it didn't know what it didn't know. And I think that is one of the problems with arbitration, whereas a court would look at things quite different. But it does raise one question. And sorry, this debate about an overbroad discovery versus a very narrow discovery is not a new debate. It happens all the time. I see it in the domestic market in South Africa, where we have a very privatized litigation-focused style of domestic arbitration, where we often have practitioners running domestic arbitrations in accordance with high court rules, which obviously introduces an expanded discovery process, which then results in your arbitration, which could be completed in 2 to 3 days, running over weeks. unnecessary evidence, discovery processes lasting months, which is totally unnecessary. So I don't think we should be throwing the baby out with the bathwater here. We need to focus on what is important for arbitration. And I don't think that we should have exceptional decisions clouding the real positives that still exist with arbitration. But one interesting point that I was thinking about reading this decision was the concept of a document hold. And not all legal systems require that practitioners put a hold on evidence. And a matter such as this brings that really to the fore. Once legal practitioners are briefed in a particular matter, some legal systems require that the client place a security hold on all documentation that may be relevant to the matter. And they secure that in a way that is retrievable and defensible from an evidentiary perspective. Other jurisdictions don't even think about it. Most notably civil jurisdictions, where they know that chance of you being compelled to disclose documentation is relatively low. There's no need to secure that information. And in this matter, the information was retrievable in due course, which helps to disclose things like corruption, which is quite important. So it's a topic of debate. I'm not arguing one way or the other, but it was just something that struck me that there was another mismatch between the two legal systems when we're talking about securing evidence prior to the initiation, or at the start of the initiation of the proceedings. But I've already touched on the role of the arbitrator in this instance. And suggestions have been made that the arbitrator should have done more. They should have done more probing, particularly in relation to the gaps in evidence. I think that's quite a risky thing to say. I think that you're asking arbitrators to stray beyond what is before them. And there is a risk that the arbitrator would attract some attention, accusations of bias or impartiality, or potentially scope creep, and exceeding the bounds of the arbitration. And the biggest concern for an arbitrator is making sure that your award is enforceable and not susceptible to being reviewed. The next point is, what is the obligation on the legal representatives? And again, this was quite a unique case because we had legal representatives that appeared to be in on it, if I can say it that way. But the judge made a few remarks about how the legal representatives might have been motivated by money, and they may have done things that they should not have done. It does open up another debate as to, well, what about solicitors acting on contingency or in success fee arrangements? In those instances, the representatives are most certainly motivated by a positive outcome because they're sharing the upside. And it is something that we need to be very alive to. And I'm not for a moment suggesting that solicitors would always conduct themselves in the manner in which the representatives did in this particular matter. But it does open the topic to debate again, is where do we draw the lines? And I think the crux of this, for purposes of the documents that we're going to be discussing now, related to the privileged documents that were then slipped across to the other side. And I think that we should just bear in mind, this is not an instance of a document, a sensitive document, accidentally ending up in the hands of the other party. It appears as though this was another instance of corruption, and the judge did talk about that in the judgment. It was designed. It appears as though there may have been money paid to acquire certain sensitive documentation, and that documentation wasn't historical evidence, because if you get hold of documentation which is legally privileged, the starting point is you cannot rely upon, you cannot use it because you are in unlawful possession of that document, which is cold comfort if the document itself discloses, for example, ranges of settlement, as we've seen in this matter. Once you've read that document, you cannot unread it, you cannot unsee it. And so the whole sort of bolted there. I think that the judge was quite right to be harsh on the representatives in this instance, where those documents could only have been obtained in unlawful circumstances. And the fact that they did not disclose them, to disclose the fact that these documents were in their possession, really questioned the ethics of the legal representatives. And I would like to think that that conduct was exceptional. We as legal practitioners are held to very high standards, and a lot is expected of us. And so there is a lot of food for thought in relation to what was said about the conduct of the individuals. And we should always bear that in mind. The last point that I just want to make before I wrap up here, which is just linking the concern that we've got, one of the primary concerns with this matter, which was made very clear in the judgment, was the lack of transparency. And if this was made open to the public, number one, the parties may not have done or said what they did if they knew that they were being scrutinized. In other words, if they were in the public eye, they may have conducted themselves differently. And number two, information may have come to light a little bit easier if people could scrutinize the evidence as it was then being presented. And what happened in South Africa, when South Africa adopted the new International Arbitration Act, there was one section in that act which largely slipped under the radar, which has become a little bit more relevant in light of this decision. And it's Section 11, very short one, which says, arbitration proceedings to which a public body is a party are held in public unless, for compelling reasons, the arbitral tribunal directs otherwise. Now, that's quite at the time, it may have been controversial. It was also shortly after South Africa had announced the termination of the BITs and the purported Protection of Investment Act, which changed the regime of investor protection in South Africa. But this particular section is incredibly helpful. And it simply says that any proceedings to which a public body is a party are held in public. And I think that if we see more jurisdictions adopt that as a starting point, I think we can address many of the concerns that we've identified from this particular judgment. And we open the doors to people to interrogate the evidence as it's been presented, uncovering corruption where it is. There are fewer places for dodgy parties to hide. If you've got a criminal and a state entity that are in a corrupt relationship, there are fewer places to hide if they go into arbitration. And then we are not in the realm of criticizing arbitration because it is no longer sufficient to resolve these disputes. I think it is still sufficient to resolve these disputes. It's just done in a public way, which addresses the public concern side of things. It does go to the heart of one of the core principles of arbitration, that proceedings are confidential, but I think that we can all accept that principle shouldn't always apply, particularly when we're dealing with public bodies where there needs to be accountability. And Jackie, I'll stop there and hand back to you.
Yes, thank you, Jonathan. We've really enjoyed hearing you bat for team arbitration and arbitration still being very relevant in dispute resolution, particularly at the international level. And I think, okay, I'm not so sure the guys in the public sector want to be associated with corruption, but I guess it does sometimes come through that way. But I believe your last statement on the question of us being able to hold arbitration proceedings in public, okay, that is quite a revolutionary idea. But it seems that South Africa has actually legislated it, and it works for you, and it actually does create a firm foundation on which an arbitrator can say, look, this is what we're going to do because it's what the law provides, and it is actually the best thing to be able to scare away the specter of corruption. So that's actually a pretty good take home from the jurisdiction, your jurisdiction as well. I liked your comment that criminals are not usually alive to the evidence that will implicate them eventually. You have a lot of faith in everybody who is involved in the process. Some may be a little bit more sophisticated than that, but it is good that the frameworks that we currently have for discovery tend to bring these very important issues out. You spoke about the red fund schedules. Just for the benefit of those who may not be familiar with them, maybe you can just say one or two, probably what to include and what to exclude, and also how all the parties also respond to the schedule, so that by the end of this whole process, we have a shorter discovery period, which also highlights very specific issues. I liked your comments about what shouldn't have done with the privileged documents. We tend in Kenya to be more inclined towards legal professional privilege. You may also just want to say something on settlement privilege, if just in a small bite-sized comment. And also on all these issues, thank you for highlighting the obligations of the legal representatives as well. Thanks.
Sure, I'll just be quite brief. Just a word on Redfern.
Yeah.
And Redfern, there's no magic in Redfern. People who know Redfern, they know it comes from a particular well-regarded textbook. And it simply is a process of targeted discovery. And it really was trying to blend the needs of the civil lawyers versus the common law lawyers. It does away with the blanket requests to disclose all and every document relevant to the matter. It says, okay, but what does that mean? What is it that you need to establish your case? Be targeted, and you have to be able to identify a document. So that's the starting point. And in the schedule, it's simply a schedule that sets out documents that you require. And normally, the one challenge and the criticism of Redfern is you don't know what you don't know. Now, that's normally a common law approach to it, but I don't know what's there. The civil law lawyer says, well, then clearly you don't have a case. If you don't have the evidence, you don't have a case. So Redfern tries to find a space in between, and you can describe a category of documents, but you have to narrow them down. And there's normally phases for objections, and then ultimately a determination by the arbitrator whether they're going to force disclosure or allow the documents not to be disclosed. So it really is a mechanism to manage the disclosure of documents. It usually works quite well. There are the exceptions, but the arbitrator does have the power to do whatever he or she wants, ultimately, within the four corners of the rules. And just quickly, settlement privilege as well, because that was quite topical in this decision itself. Legal professional privilege is also a bit of a nebulous concept, and it applies differently in different jurisdictions, which makes international arbitration quite tricky. The big question is what law applies to a particular piece of advice given to the client, for example, an advice privilege. But I think that the starting point generally would be the regime in which that evidence or that advice was given. So if it's a South African client and I'd advise them, the South African law privilege would attach to the information itself, the evidence. Settlement negotiations in most jurisdictions, are also protected by a form of privilege. And the one reason why you do that is to make sure that the parties are free to discuss settlement and try and resolve their disputes without fear that information is going to be disclosed to anyone else, especially a tribunal. So it might influence other parties. And that's one of the reasons why your advice that you get from your lawyers about a settlement is incredibly sensitive. And that is the type of information that was leaked in this particular matter, because obviously it's very important or very useful to the other side to know what your range of settlement is, for example. So there's the settlement privilege, which then stays between the parties, but then there is legal privilege, legal professional privilege within that, which is the advice to the parties, which is the documentation that was leaked, some of the documentation that was leaked.
Okay. Yeah. Thank you so much for clarifying that and for your presentation as well. I just allow me to take a moment to recognize the presence of Professor Onyema. I think I've seen her in the chat. She has shared with us the link for the case. Thank you so much, Professor. It's a privilege to have you here with us, and we do not take it for granted. And Mrs. Funke has also shared some links and the reference to the UFOS case, and she has her hand up, so allow me to just give her the mic for a moment.
Thank you very much. I have a question for Jonathan, if you do not mind. And
Okay.
my question for Jonathan is, to what extent do you think that if the counsel in the arbitration had properly utilized Redfern schedules, the information about corruption, about the manner in which the extent to which the claimants were ready and available to perform would actually have been disclosed, noting that Redfern schedules go to relevance and materiality, and linking that as well to the statement of defense.
Yes. You're absolutely right. I think that's linked to the point that I was making is I don't think that the corruption evidence would have actually come to light because, again, criminals don't want to disclose evidence of their criminal wrongdoing. It may have assisted in relation to some of the factual issues relating to land and the like, if those were the issues that were currently in dispute. But again, you need to know what you're looking for. And that's one of the challenges with the Redfern schedule. You need to know what you're asking the other party for before you ask them for it. Whereas in this instance, and I think the real benefit of the broader discovery once we went into the court realm was that there was a much broader duty to disclose a lot more information than a document that was asked for. And so I'm not entirely sure that doing the arbitration in a different way would have brought the corruption to light. But I'm not entirely sure that if this matter had presented itself in a civil trial in South Africa, the way that we would have done our jurisdiction, that we run our litigation in this jurisdiction, that the corruption would have even come to light. I think that it was other evidence that had to spark the concern, and then you have the targeted discovery process in order to get hold of that information. And I think that could have been done in an arbitration. But it was the point there is that we didn't know, the parties didn't know what to look for at that point in time, or at least appeared that way. So I'm not sure Redfern would have necessarily helped on the corruption point.
Okay.
I hope that answered.
Okay. Yeah, I think, you've answered, Funke. I think basically at the end of the day, we still expect that Redfern is very useful for shortening the process, but again, it is not a silver bullet. So we still need to be on the lookout so that particularly when we are case counsel, appearing as case counsel in the arbitration, but also as arbitrators, we just also need to have our eyes peeled out so that we can be able to identify what may be important or relevant. Worry that there is the element of bribery, corruption, or even just plain dishonesty. So now we have a few questions here, and I have Dr. Mutupwa also, and they're coming fast and furious. So let me do this. I think, Mrs. Funke, there's a question on the DCF, and this is from Trustee Chikwano Madumere. He's wondering if DCF methodology is applicable to all substantive breaches or preferred for certain substantive breaches. So all or certain, please put a pin on that because it's going to come to you. There's somebody who has asked here, this is John Mutwa. If the case had been decided in Nigeria, would the outcome have been the same? Possibly. And Professor Onyama has weighed in, and she has said that maybe, but would it have been so well reasoned and received by the international arbitration community? Or would the Nigerian court have been accused of being partisan? So that is a lot of food for thought, because those are the issues that keep on being thrown into our faces when you get onto the international platform. And senior counsel, Professor Muigai, there are comments here about Article 5 from QS Nyaga Kithinji. What do you think of this? This is the New York Convention on the enforcement, and I guess pretty much what he's suggesting is that the window for courts to intervene where gross injustice may result from the enforcement. Please keep thinking about that as we move along. There's a question here on the local jurisdictions. So any one of the Kenyan panelists can consider it from Isaac Alwochi, and it relates to Article 50 of our Kenyan Constitution about everybody having the right to have a dispute resolved by application of law. There's a full question, but I will read it out when the time comes. So, and Rehema Twine, I hope I'm pronouncing that correctly. She says that it is important to highlight the responsibility of states for the actions of their officials. Should a state be exonerated for corruption and bribery tendencies because it was done by its officials? Generally, states work through officials or individuals. So there's a philosophical question there as well. So, Dr. Mutupwa, I want to invite you to speak on the question of investment decisions in investor-state dispute resolution. And please feel free to address any of the queries that may have come in the intervening period. Are you with us? If so, yes, I want to hand the mic to you.
Yes. Can you hear me, Chair? I hope you can hear me.
Loud and
you can
clear.
see me. Thank you very much, and thank you very much for the invitation. I want to say that I am honored to be here. It's a privilege to speak to all of you, 140 plus, who are interested in this. It means that it's an important discussion. I want to take my 20 minutes to speak about some issues that I have drawn from the decision itself, having read it several times over, and just to present food for thought, largely to point some landmines, to point to some landmines, lessons, draw some nuances, and challenging notions that challenge the practice of arbitration as we know it. Coming after Learned Silk, Professor Moigai, Mrs. Adekoya, and it's very difficult to say that there's something more that I would say outside what have been said. But I want to take my 20 minutes just to reflect on this decision and to add some local flavor, just to compare and contrast the practice of arbitration as we know it here and in Africa generally, and what the decision of the judge may import. And I have taken time to address 4 issues. I have identified 4 issues and I want to look at them sequentially. But the beginning point is to say this. When you read that decision of the judge, you notice that Judge Knowles does not directly find fault in the actions of the arbitrators or the arbitral process per se. The arbitrators don't seem to have been faulted in terms of what they did or did not do. And he even, in fact, sympathizes. He looks at the arbitrators and says they were not privy to certain material that he had to look at to make the decision he made. And therefore, that takes us to the place where we ask ourselves, what exactly is the standard of proof? What is the requirement? What is this that is the legal obligation of an arbitrator when he receives evidence from parties, claims, and you have to adjudicate those claims on the basis of the evidence presented before you? And granted, arbitrators, unlike judges, have a limited jurisdiction. They have limited sanctional powers to enforce or collect evidence or even inquire into certain matters. And I want to begin by going to the first element of the first issue I teased out from the decision. And I asked myself the first question. And because when all is said and done, when you look at that decision, when all is said and done, looking at the matters of expert evidence, the pleadings, the conduct of the parties, really it came down to 2 very important considerations by the judge. The first one is a question of bribery or corruption. And the second one was really on the question of the breach of legal privilege as we know it, legal professional privilege. So the judge, that is really what turned the decision. And when you look at it, you see that the judge had benefit of a lot of information that was new material, information that, can you hear me? Sorry, Jackie.
Yes, loud and clear.
Somebody was speaking. All right. And when we begin, I say this decision is an important decision, but it is not necessarily, just a minute, sorry, I think I need to power my gadget. All right, thank you. It is an important decision, and it is important because it gives us an opportunity to reflect on the traditional concepts of arbitration as we understand it, knowing that this is not the first time that a court of law has set aside an arbitral award on account of corruption or serious irregularity. But these kind of decisions come once in a long time. And therefore, it presents a very important and unique opportunity for practitioners in this area to then reflect upon the impact or the import of that decision to the practice of arbitration. This is not the first time that corruption has featured in arbitration, particularly as a basis for setting aside an arbitral award. And I want to take this decision, compare it and contrast it with the previous decisions we know very well of the World Duty Free case versus the Republic of Kenya, 2006, and what I call the World Duty Free case number 2, a decision handed domestically, locally by Justice Tuyot in 2018, Kenya Airports Authority and the World Duty Free. I mean, These are the decisions which speak to the issue of bribery and corruption. But the question that comes to mind, and when you look at the analysis of the judge, of the incidences which he finds point to bribery and corruption and breach of honesty, what comes through is that you ask yourself a very simple question. Has the standard changed? Has the standard of proof of these very serious allegations changed? And in the analysis of the evidence, you will notice, one of the things you will notice is that the judge, number one, had the benefit of certain information which was not before the judge, the arbitrators. Secondly, you also notice that traditionally allegations of fraud, bribery, illegality have been taken very seriously. In fact, many of those allegations in many set-aside applications or many of the defenses raised in that regard have always fallen by the wayside because of failing to meet the evidentiary standard. And therefore, the question I asked myself is, what is the standard coming out of this decision? Has it shifted the position? Has it improved the clarity in that area? And you notice that the judge, and I'm not saying that the judge is wrong, but I'm saying when you look at it, the judge seemed to paint a picture of chronic corruption, particularly within the public sector in Nigeria. And he seems to be very influenced by that notion. And therefore, you find that there is, in fact, almost a suggestion to anybody that, look, the incidences of impropriety, particularly in terms of corruption, as painted by the judge in other transactions which may not be directly related to the dispute before him, seems to have influenced his thinking about the whole transaction and the underlying contract itself. But you will almost see that the judge is drawn towards inferences, innuendos, circumstantial evidence plays a very big part. There is no direct evidence that links some of those payments that he has made to particular actions that relate to the contract itself. But you will notice that he says that they draw an irresistible inference that there is conduct that would be described as being untoward or corrupt. And therefore, one would ask, does this therefore mean that it is enough? Because ideally, one would say that the standard of proof of corruption allegations, of bribery, serious allegations that go to the integrity of the people that he says were not parties to the dispute, but who were players in the matter, either at the level of contract or in the dispute itself, in arbitration, he says these are matters that are important. But you know, when you look at the analysis of the evidence, I don't know whether some of you have looked at the quality of the evidence, how compellable the evidence looked, and the material that was put before the judge. And you want to ask yourself, what is the standard now? What does this new decision say about what we should do as arbitrators, as party representatives, in terms of establishing an allegation of fraud, bribery, and corruption? Is it still a test higher than balance of probability, maybe not as high as beyond reasonable doubt? That intermediate test that we have always used, has it been met in this case? Has there been a shift slightly towards a balance of probability, or a less stringent test as we understand it? So that is the first question I ask myself, and I don't think I have an immediate answer. The second aspect I looked at in this case is the impact, the general impact of the decision on the practice of international arbitration, particularly investor-state disputes. And I wanted to look at it from the perspective of looking at what would be the ideal situation, looking at an arbitrator seated under the review jurisdiction of the court. I then compared and contrasted Section 68 to the model law, which is applied in many jurisdictions, including Kenya. And I know many of the people on this platform practice arbitration also at the local level, and we apply the Kenyan Arbitration Act. So allow me very briefly to just compare. What is the impact of this decision? What would it mean for the practitioner here? What does it mean to us? How will it work perhaps in the context of our domestic arbitration here, or in arbitration, commercial arbitrations within the region? Now, when you look at the decision of Justice Knowles, decision handed by the High Court, an English High Court, the decision in itself is of persuasive value to us. It may be useful for us to look at it and use it as a persuasive authority before our courts in Section 35 applications for setting aside. But when you look carefully at the wording of Section 68 of the English Act, the court seems to have a wider latitude to interfere with arbitral awards, and the use of the phrase serious irregularities. Now, you see, the court found that there were serious irregularities which would commend the award to being set aside. Is that the same thing as what we have in Section 35, for instance? In other words, can the decision of Justice Knowles be applied in a Kenyan court with the same impact or effect as it would in English courts? First of all, we all understand that in the hierarchy of our in the judicature, in the hierarchy of our sources of law, the decisions coming from the courts in England may be of persuasive value, but after many other decisions, including our own High Court decision. So insofar as we are concerned, in my view, the decisions of the High Court, including the World Duty Free case number 2, is of more binding or more effective value to a practitioner and courts here than the decision in that we are discussing this afternoon. This is still an important decision because it affects the international practice that is arbitration. Now, when you look at Section 68 and you compare and contrast it to Section 35, while an arbitration award may not be set aside in Kenya on account of serious irregularities, that is not the wording of our statute, but fraud, bribery, and undue influence and corruption is a direct ground for setting aside an arbitral award. And the wording actually of the Section 35, Section 35 6 is that the making of the award was induced or affected by fraud, bribery, and undue influence or corruption. Now, generally speaking, Section 35 speaks about the process of arbitration and the award itself. So the making of the award. The wording used is the making of the award and not necessarily the underlying contract. Remember, the entire underlying contract can be found to be void. In fact, it is against public policy that you have an award or a contract that is fundamentally or is founded on corruption, for instance, or procured through corruption. But the question is, what is serious irregularity in the context of a model law jurisdiction like ours? Is it the same thing as what is expressed in Section 35? Now, remember, when you read this decision, you will notice that there was an entire trial in the High Court of the matters that were raised before the award was set aside. Testimony and all these matters were put. Is that the same procedural matter? Is that the same procedure that is taken under Section 35? So of what benefit? What is the effect? What is the impact and the import of this decision? When you look at the conduct of the arbitral proceedings from the perspective of the arbitrators and the manner in which they carried out the arbitration, I find very little criticism from the judge. However, you see that the court could still have reached the same conclusion had it only looked at the matters of breach of privilege, legal profession privilege, particularly on the aspect of the documents and how the documents were then gotten by the counsel for the claimants. Again, what most important issue that we may have to grapple with is the effect of contingency agreements, particularly by counsel in international arbitration and even domestic arbitrations, because there is criticism of the motivation of counsel particularly the counsel appearing or the representatives of the claimant in the arbitration based on their perceived interest in the outcome of the arbitration because of a financial gain on incentive. What do we say about these incentives vis-a-vis third-party funding, for instance, as we know it today? Because third-party funding is about incentive. The incentive is a portion of the money that is going to be made out of the arbitration. Third-party funders want to have an influence or exert an influence as to who represents the party. So going forward, as we look at third-party funding and the legal framework that we want to make for ourselves, for instance, in Kenya, is it important for us to consider some of the comments that have been made by the judge in that context? Now, the textual differences between sections 68 and 35, notwithstanding, you will notice that the principles of arbitration, for instance, the confidentiality of arbitration, is one thing the judge has criticized extensively as having contributed to the opaque nature in which the proceedings were carried out and the ultimate outcome which he found to be flawed from the beginning. Now, I also considered what options were open to the judge. Now, the Section 68 of the English Act looked against the model law Section 35, for instance, of our Act. What would have been the best outcome? And this is a matter of debate. And I asked myself, wouldn't it have been a better option, for instance, for the judge to have exercised his discretion under Section 68(3) A and remit the award to the tribunal to consider the import or the effect of this material that he used to nullify the award, to consider the effect of that material, that new evidence, and consider that as against all the other matters to reconsider the award? Or should we look at our Section 35, which also has the same consequences or the same discretion available to a court, and ask ourselves, is the review jurisdiction under Section 35 limited? Are we better off having a Section 68 approach where the judges can make extensive decisions like Justice Knowles made? Or should we confine ourselves to this situation? Because ideally, a judge who comes across this kind of evidence, which was not before the tribunal, but is so material in determining or helping to determine the merit of the decision, would gravitate towards sending the matter back to the tribunal for a reconsideration under Section 68(3)(a). Now, the review jurisdiction of the court and to what extent that review jurisdiction would then be exercised is a matter that you can clearly pick out from that decision as being something novel that requires us to think whether the provisions of Section 35 as we see them in our own local statute is something we could borrow from the extent to which the judge took the inquiry. Now, one other thing that I reflected upon reading the decision is the element of finality of arbitral awards versus the adversarial system that we are used to as common law lawyers in the presentation of cases. And Senior Advocate Adekoya, Mrs. Adekoya, has spoken to this and said, look, there are varying shades of preparation. You get a good lawyer who is incisive, who is well prepared, witnesses who have been prepared with proper experts, experienced experts on one side, and you find the other side basically coming with the very bare minimum. How does that work in a real situation? Because in an arbitration system like ours, you are used to a contest which is adversarial. You bring your case, make your case, and if you don't prove, it is dismissed. If you prove, then your case is allowed. What happens? Where is the obligation of the arbitrator or the tribunal to ensure that parties have almost an equal ability to present their case? Is it even is it an obligation really that should be borne by the tribunal? And when you look at the jurisprudence that has developed over time in this area. One of the things that happens is that the courts will tell you, look, before you bring material before us, that is material you did not present before the tribunal, you must demonstrate to us that having used every effort, diligent effort, you were not able to get that material, or that it was not available at all. And in those circumstances, what happens? What does the tribunal do in those circumstances? What does the court do? Does the court say that this material indeed could only be procured after the matter has been determined, or could not be procured even with the best effort during the time the matter was before the arbitrator? And therefore, having seen the material, we want the tribunal to consider fresh the matter on the basis or with the benefit of this evidence. And that then takes me to the next point. What is the best recourse in the circumstances? Is it the setting aside of the award, or is it remission? What is the review jurisdiction of the court? And to what extent can a court then refer a matter back to the arbitral tribunal? Lastly, let me say one or two things about two side issues that I noted. This decision also brings to the fore one of the questions that is now lingering before the UNICITRAL. I think that is the working group 3. Damages and the extent of damages. When I was last in Nigeria a few weeks ago, what I heard the Attorney General saying and many people saying is about the damages. And you heard the chair speaking about the extent of damages in arbitration. And the debate has always been around the quantum of damages that is handed down by arbitral tribunals. 6 billion plus interest. And you know, this is a discussion that has been building from the UCOS case, now the P&ID case. The concern is with the amount of money that arbitral tribunals are awarding investors. And this is becoming a concern to developing countries particularly, and the ability of those countries to actually properly defend or even honor arbitral awards. And therefore, this tells you that the discussion at the level of policy, at the level of the international commercial trade and commercial and trade law is to discuss the effect of this decision on the question of quantum of damages, or the damages that are awarded in international arbitration, particularly in investor-state disputes. Corruption also, I noted that when you look at the text of the decision, if you read through the decision of the judge, one thing stands out. It breaks the old notion that corruption resides in certain parts of the world. And it tells you that corruption is a two-way street. And it tells you that it is not just the monopoly of African or African lawyers, that corruption is not just conducted by people in Africa or Africans. You could see that English barristers, English solicitors were also being adversely mentioned in these matters. And therefore, it tells you that to deal with corruption at the pre-arbitration level, and even within the context of the arbitral process itself, it takes more than just saying that it happens in certain places or with certain people. I must say this as I wind up, Chair. The decision of the judge is, it's a good decision. It's an eye-opener. It's a discussion area that gives us an opportunity to reflect on the traditional notions of arbitration, particularly on setting aside arbitral awards, on corruption, on conduct of counsel, whether counsel need to be held at the same level of accountability as the arbitrators. But it also gives an opportunity to reflect and ask ourselves, where do we stand in terms of the law on the standard of proof on questions of fraud? Are we still at the same level that the World Duty Free case left us? Or has the level or the yardstick been put slightly lower? You will see that the judge takes acres and acres of his decision to discuss many other contracts, many other relationships between the Nigerian oil and gas and energy entities and dealings with other bodies which were not parties before him, to create that impression, to create that almost picture of a place where corruption is deep-seated. And again, I say this, if you interrogate the underlying contracts and how they are procured in Africa and in many parts of the world, and you infer that certain conduct, because this person knew this one and spoke about to this one and got this contract, then it must be some corruption, some corrupt deal must be behind it. I do not know how many contracts in Africa will stand, because it is difficult to get a contract in Africa without knowing somebody or speaking to somebody in one way or another, even without giving consideration. And this therefore presents a very big challenge, particularly to contracts and underlying contracts, particularly, and the way they are procured, how they are negotiated and eventually executed. So these are some of the questions I picked up. The question eventually is, has the practice of arbitration been dented by this decision? One of the things I would say is that a decision like this comes once in a decade. The last time you saw a decision of this magnitude is 2006, and now perhaps coming in 2023. What it does, it tells you that many arbitral tribunals are doing a good job. Many arbitration proceedings have gone on well. Perhaps we may not know what has happened in others which have not come to the English courts or to the High Court, but the essence of a setting aside proceeding like this one is to also suggest to us that there are areas of improvement in the entire ecosystem itself. Thank you very much. I will await the questions.
Yes, thank you, Dr. Mutuba. There's another one for team arbitrators and team arbitration, particularly on the international level. I guess we are all in agreement that this is it may actually be once in a lifetime, but Dr. Mutuba has narrowed it down to once every decade. So we have a lot to learn from it, and we are able to champion arbitration. I think the first thing he said was that there was no direct fault that was laid at the feet of the arbitrators, which was a good thing, notwithstanding the majority decision. Probably what I can say here is that I'd hoped that I had a mystery guest for today. That was Chief Bayo Joe himself. Unfortunately, he tells me that where he is, the internet is not so reliable. But our Nigerian compatriots, please pass our message of admiration on the way he handled the dissent, which also enabled the challenge, and the outcome of which was Nigeria versus PNID, which we're discussing today. Thanks, Dr. Mutuba. You also touched on the question of bribery, corruption, the standards, the levels. You also brought it down to also what we experienced with the World Duty Free case in Kenya, and looked at our Section 35 of the Arbitration Act as compared with the English Arbitration Act, Section 68. So there's a lot to ponder on. There's a lot that we have learned today. This has been very intellectually stimulating, and that my fellow members and everybody who is on this call is what we've heard from our panelists. Now, before I call on Professor Gidu Muigai, because he had said that he was going to take back the rest of his 10 minutes, allow me to take this moment to recognize the presence of Dr. Sylvia Kasanga, our treasurer, honorary treasurer, retired Lady Justice Mary Angawa, also the member of our board, and the other directors who have also seen our engineer Frederick Odhiambo, as well as our director Jane Mwangi. And thank you all for supporting this initiative. And thank you to the panelists. Thank you for your questions. They have been coming fast and furious. Professor Gidu had spoken, well, I'd read out a question for you. There's a question on Article 5 of the New York Convention, and I hope Mrs. Funke Adekoya's son, you'll also be ready. There was a question on DCF as well, and Dr. Mutumbo, you seem to have answered. This is a question from David Kagwa about what you described as the acres that Justice Knowles extended to setting out unrelated third-party transactions. So I believe you've already covered that, but there's Henrietta Woloyo who asks about the fraud discovered on appeal. Does this mean arbitrators have to be alive to possible fraud in disputes between states and investment companies when conducting arbitral proceedings? And then Mutua says that maybe more transparency is required to ensure the integrity of the arbitral process. I believe this relates very closely with what Professor Giddu had spoken about. Professor Giddu, are you still with us, or are you present? Are you in a position to answer this, or I can allow Mrs. Funke Adekoya to give her last comments as she answers the questions that
I have
been...
unmuted, Madam President.
Okay, so we'll allow
And
you.
maybe I should come on video for a few minutes because you seem not to believe that I am here.
Yes, please do.
Oh, the video is another problem. Unmuting it is a big problem. Okay, let me make a few comments. Comment I want to make is about a public policy. I think even if this award had passed all other scrutiny, it would, in my mind, have been against public policy to allow it to stand. And I don't share my friend and fellow arbitrator's skepticism about the standard of proof. I think the judge really goes out of his way to address that question. And he keeps saying, I'm not looking at the merit of the decision. I am not sitting on appeal over the tribunal. My standard of proof here is very clear, and he goes into that on a balance of probabilities. I thought that the evidence the judge was looking at was overwhelming. We didn't need, he unearthed, or rather he was presented with almost 20 different acts of corruption. Money paid to the individual, money paid to family members, money paid before the contract, money paid after the contract, money paid when the dispute started, money paid after the dispute had been processed, money paid after the success of the claimant. I don't agree with Dr. Mutumbwa, with whom I sit on many panels and is a highly regarded arbitrator by me, that there was a standard of proof problem. In my view, there wasn't. Secondly, I am on the question of conduct of counsel. I don't know. I know we have our Nigerian colleagues and brothers on the call, but we have two problems with counsel conduct in this matter, in my opinion. Maybe three. There is counsel conduct inside the government, legal advisors inside the government. Because, first of all, I find it quite surprising that for a contract of this magnitude, the potential investor casually shows up with a written contract himself. There is no process of negotiation. There are no heads of agreements. No, he has drafted the entire. That is, for me, that should be a red flag for counsel inside government, whether inside the Ministry of Justice, inside the Solicitor General's office, wherever it is, that should be a red flag. Because the proper negotiations of a contract, we all know. Secondly, I am surprised that there isn't a public procurement process in a contract of this magnitude. Indeed, it appears like it is the advice the minister is receiving, the advice the attorney general is receiving, the advice the president is receiving is, we have a new whatever here, let's accept it. In fact, at one point there is a conversation about, but isn't it preferable to have so-and-so? It's not a technical evaluation. That surprises me as far as council conduct is concerned. This conduct is external counsel inside the state itself, whether it is Kenya or Nigeria. Once the government of Kenya has said, we have contracted the firm of K&K to advise us, that conduct of counsel there also does not rise, in my opinion, to the appropriate standard. And thirdly, and more problematic, is the conduct of external counsel, who is representing the claimants. Now, that is totally beyond the pale, and the judge deals with it very, very well, in my opinion. I do not think that, my colleague from South Africa dealt with that point very well. How can you possibly be holding in your hands your opponent's file and not have any ethical qualm that you are holding your opponent's file in your hands? You know everything, what his instructions are, what his parameters are, and this is not disclosed. And this does not come to you by accident. So you are privy to the process that corruptly procures your opponent's brief. That is beyond the pale. And I think that that is a big blemish to the standing of the international commercial arbitration. Because if this was raised even in an ordinary local state or county court, the judge or magistrate would have very harsh words. And in my view, that was quite sad. So I make my last point again, that the lesson I draw from this case, especially drawing on my previous experience as the Attorney of the Republic of Kenya, is that government must have a cohesive and coherent way of processing not only the contracting, but the dispute resolution process. In this case, the ball was dropped so many times, and I think, Dr. Mutubwa, that is why the judge is very sympathetic to the tribunal, because the tribunal is not receiving much help from counsel, not much help, to be honest. And time after time, there are delays in filing, there is failure to, I don't have instructions. That is a problem with the government itself. An advocate cannot plead a case he doesn't have instructions on. But I think finally, before I yield the floor, there is another reason why the judge does not want to critique the tribunal's conduct. First, he doesn't want to be seen to have descended into a merit-based review of the award. He's very conscious that if he has a if he's seen to have a merit-based review, then of course he will be critiqued for having stepped out of his jurisdiction. Secondly, the panel is extremely distinguished. And I think the judge is very cautious not to appear to imply that some very, very distinguished English law lords can be, can be so misled and misdirected. I think those are the two reasons. I'll stop there for the time being. Thank you. I hand back to you.
Thank you. Prof, you're being very measured with your words. I think, thank you for the comments that you have made, particularly about the very distinguished, I think this is Seema Sandhu and Trevor Burke, KC. They have both since denied any wrongdoing, and although they have also been presented for, I guess, the equivalent of the disciplinary tribunal for solicitors in the UK. And thank you so much for your very, very elucidating comments on this issue. We'll take it that these are your final comments, Prof, unless you want to add something as a take home for everybody who is here listening to you.
Well, like my friend, Dr. Mutubwa, I take solace in the fact that this case, as tragic as it is, demonstrates that the entire arbitration community shares the same challenges and problems. And we have been fighting two perceptions, and I think we are beginning to win on them. We were fighting perceptions that African arbitrators are not equal to an international challenge. My good friend, Chief Bayo, demonstrated in this particular case that he had a superior grasp of the law and the evidence. And I think that's a big win for us in the long run. The second one, it was presented as if arbitrations taking or involving African countries are inherently susceptible to corrupt practices. This case has demonstrated we are looking at a global problem. And so in this very tragic case, we have found some redemption. Those are my last words.
Thank you. And actually, you're echoing Deborah Chukwedo's comments. She says that now that we can prove corruption goes both ways, perhaps it's time to consider sanctions on corrupt investors as well, as it is happening more and more often. So I think one of the things that take home that we have is that more likely than not, we will see a push, if you like, towards boosting efforts to address the real question of corruption risk in arbitration as well, and also have a structured way, a standardized way of dealing with it. I'm also trying to be as measured as Professor Muigai, but I feel like I'm not winning that particular war, so I'll stop at that particular comment. Dr. Mutuba, I see your hand up, but I'll give you a right of reply. I want us to address the issues as panelist by panelist in the same way that you participated. So I don't know whether I beg your pardon, this is Mrs. Funke Adekoya. I want to give you that opportunity, address any of the questions that have been raised in regards to your presentation, and also give us a parting shot, if you like.
Thank you very much, Chair. The question that has been put to me has been in respect of use of the DCF and whether it is for all or certain preferred breaches. I think that the DCF is the preferred method for long-term investors or investments because it calculates into the future. And therefore, in respect of investor state, you will always see a claim being based on the DCF. Having said that, the longer the forecast, the greater the number of assumptions, and the more the opportunity to challenge aspects of the assumptions upon which the DCF is used to calculate the damage claim. And the change in the assumptions can lead to very wide changes in the number of the damages. And therefore, my last word on the topic is that the defense of investor state claims from the perspective of African states really depends on the quality of legal representation. And I want to use the opportunity to echo something that Professor Mugai said at the start of his presentation, which is that where we do not within country have the expertise we should not hesitate to use international legal counsel. I know that Kenya has done this successfully on, I think, 2 occasions. The only thing that I would like to add to that is that perhaps when co-counseling with international counsel, our state governments should ensure that part of the hiring terms is that state counsel or local counsel or domestic counsel sit in the offices of the international counsel abroad, wherever they may be based, for the period of the dispute or the proceedings, so that they learn to imbibe how research is conducted, how processes are drafted. It's not just a question of using local counsel and they review positions on Kenyan law or Nigerian law or Ugandan law. That is one way in which we ourselves can get the required skills-based training whilst ensuring that we have proper representation. The last point I'd like to make is that I think it is unfair to criticize the tribunal. They did not have the facts, as Lord Noel said, they didn't have the facts that became available to them after a discovery process which the court allows. And after Nigeria, having got the award on liability, then committed the resources to finding out from various jurisdictions the relationships between various companies which enabled it to put forward a full-blown fraud allegation. The point is, they used the hand they were dealt with. The truth of the matter, if it must be told, is that Nigeria did not have adequate legal representation, either at the tribunal or when we got to the courts. And that is our fault. Thank you.
Thank you, Mrs. Funke Adekoya, for those very candid comments. But I think overall the outcome suggests it was important to do all those other extra investigations, and notwithstanding the fact that a lot more could have been done. Jonathan, you're next. As you're coming on, I'm seeing Edward Luke. I'm not sure why I hadn't seen him earlier before. Edward Luke II is also with us from the southern parts of Africa, so he's also batting for that team. And there you go, Jonathan. Yes, there you are.
Okay. I'm not going to take too much more time, unless there are some pointed questions. But there was one comment that I saw in the questions that popped up, which I thought was possibly a sensitive topic, but quite relevant. And it was simply the question of, if this judgment had been written from a Nigerian court, would it have been received the same way that this one was? And it's a very important point. And I think that we have to accept that it probably wouldn't have been. And that is just a symptom of the system that we are dealing with at the moment. And I think the fact that we've got a judgment written as concise, well, I don't want to call it concise, but clearly as it has been written, that is of such value to people in other jurisdictions, I think that we have to really appreciate the importance of this decision for us. Because of where it came from. I think that it is incredibly helpful for people not in the UK, that we can have a judgment like this from the Supreme Court. But unless there are any pointed questions, I'll hand back to you, Jackie.
Thank you so much. Okay, coincidentally, when you were speaking, the president of our Court of Appeal, the Honorable Mr. Justice of Appeal, Daniel Musinga, has joined us, and maybe we can also recognize his presence, my lord. I wouldn't put you on the spotlight, but at least thank you so much for honoring our webinar. And finally, I want to call upon Dr. Mutubwa. You have a right of reply. Keep it brief and short. You're
Yes,
almost
I
at
want
the
to be
end
brief.
of things. Yeah.
Thank you, Chair. Now, I hear my senior friend and colleague. My point was this. Justice Knowles takes hundreds of paragraphs going through many, many things that are outside the context of the parties of the arbitration. Remember, As tribunals, we are given a circumscribed jurisdiction specific with issues and parties who have an agreement to arbitrate before us. One of the challenges you face as an arbitrator is this. If you start wading outside the remit, outside the four corners of your jurisdiction, you are inviting a challenge upon yourself. If all those transactions, relationships involving many third parties were matters that were considered by the arbitrators, if those were matters put by the arbitrator, parties who are not heard, parties who had no opportunity to say anything before the tribunal, and most even before the court, would the court have sustained that decision of the arbitrator? Remember, we are told, look, you are not going to hear somebody and to condemn somebody unheard. But here you have a situation where, in my view, I do not say that the judge reached a wrong conclusion on the questions of bribery or corruption. I think if you read every paragraph of the allegations of bribery and try to tie in the claimant and try to say, I want to apply a standard that is high, not just inference, suspicion. There is a possibility. The judge uses the words, there is a possibility, there's a strong possibility that corruption. There is no other way to see it, but there may be corruption. In fact, if you went before a court with those terminologies in your award, suggesting that you have investigated fraud and on inference, on impulse, on feelings, on the views, you have reached that conclusion, you will be told that this is not the threshold. My worry was that the judge, and my thinking, my suspicion was that the judge was building a case, a scenario. He was building a narrative so that when he gets to the circumstantial evidence based largely on inference, because you will not see any direct transactions, the bribery. In fact, it is said that somebody was bribed to suppress evidence from coming to the tribunal. There is absolutely no relationship between that and the suppression or the element of the suppression itself. It is something that the judge then, in his own view, draws a conclusion. It could be right, could be wrong. But if this same decision of the judge was brought to him from an arbitral tribunal, you would be told, number one, you have condemned people unheard. You have gone on a frolic of your own. You have engaged in an investigation that is not material or relevant to the issues or questions before you. The people whom you purport to have investigated have no arbitration agreement or an agreement to arbitrate before you. So there are those questions. So my question was, what is the standard? Are we still where we were, or have we moved elsewhere? And is it now permissible for arbitrators, tribunals, to take up actions like Justice Knowles took in the event these matters arise? And we have not had the last of this. I want to tell you, we have not had the last of this because in some of the areas you look at, you are uncomfortable with the conclusion, but you know the conclusion has some merit. On the question of the conduct of counsel, it is completely unforgivable. It is something that is clear-cut. That is why I said the judge would still have been comfortable reaching the conclusion he did on the basis of the breach of the legal profession privilege. But again, this gives us an opportunity to reflect, to ask yourselves, does an arbitrator have the tools that the judge invoked in a review application under Section 68 to deal with these matters? And again, I wanted to ask everybody, wouldn't it have been fairer to the tribunal before you criticize them, if you want to criticize them, to give them the same material you had so that they can consider the matter with the benefit of the material which you have used to make that determination? Thank you very much for your questions.
Thank you, Dr. Mutuba. I know we will continue to discuss this particular judgment, and there are so many different aspects that still require to be explored. I think where we can end is with Professor Onyema's comment. This decision could have gone either way, but the injustice was one crying out to be remedied. I believe to respond to Dr. Mutuba, where are we right now? I think and I'm sure you'll not disagree with me, that this is now an area that is crying out very loudly for reform. And of course, the good news, either when the question of jurisdiction is being raised, or either when there's an award on merits that has been delivered, and we now have a new, the good frontier of at the point of enforcement, but at the point of enforcement, a lot more work needs to be done to sustain that challenge on the basis of, well, we're calling it bribery and corruption. I'm not so sure the word corruption is used that loudly, but there's dishonesty, there's fraud. So there are all these new terms that the good Justice knows has given us an opportunity to found any future steps towards reform in respect of what they called anti-economic crimes, or bribery, and anything within that particular genre. My fellow members from Kenya, from East Africa, we have our Ugandan chair. From South Africa, thank you, Luke, for your kind comments. Thank you, Jonathan, for not only standing in for the civil law jurisdictions, but the Roman Dutch as well, and South Africa in particular. Thank you so much, Mrs. Funke Adekoya. I really loved your presentation, and a lot of us will be very great of reference, and I do believe that it will enhance and build the quality of not only the case counsel, but also the arbitrators who will be sitting in on references, because their expectations have now been raised that notch higher. And as always, Professor Gidu Migai and Dr. Wilfred Mutubo, you have done us proud. Thank you for also bringing the Kenyan color to this particular presentation. Thank you, our trustee, Chikwendu. You always mispronounce your name, I'm so sorry, Madumere. Maybe I can give you this opportunity to say a goodbye to everyone. And my Lord, Justice is still here, Musinga. If you want to also say hello to us, we will give you an opportunity very quickly.
Thank you very much, Madam Chair. Thank you very
Yes.
much to our wonderful panelists. And
Yeah.
let's keep doing this. Thank you very much.
Yeah.
I've learned a lot today.
Yes,
Congratulations to you and to Kenya branch. Thank you.
Thank you, thank you, thank you. This is Pan-African legal thinking at its best. Judge, I said I won't put you on the spot, but it would be great to hear from you if you are able to say hello. We have agreed that court intervention is critical, and somewhat we may not have gotten to where we are with Nigeria and PNID and its explosive effect in respect to jurisprudence. I respect that you may not be able to address us. From CIAB Kenya, that is it. And thank you very much. I really do appreciate you all staying on. We had anticipated to finish and wind up at 4 p.m. It's 4:44 on a Friday afternoon. I particularly also want to acknowledge these young arbitrators I see here. I saw Wamboi Githu, maybe she may have dropped off. And I saw Tabitha Raore. This is the leadership of the young arbitrators in Kenya. I do not take it for granted that you're with us on a Friday afternoon when many of your colleagues are having a good time. To my board, vice chair, thank you very much for organizing this together with our secretariat led by our CEO and the administrative support that we had from PDM. That is Chebet Kosgei and Evelyn Wanjiru. We have come to the end of our webinar. Please look out for many more of this genre, and we may also do another one on Nigeria versus PNID very soon. If we don't see you, I want to also take this opportunity to wish you all happy holidays, and may we see each other for a brand new and very prosperous and intellectually challenging and stimulating new year, that is 2024. when a wonderful thing happens, CIAB Kenya turns 40, and we're inviting all of Africa to come and celebrate with us. I'll end on that. A goodbye, good night, and Happy New Year to each and every one of you.
Bye-bye.
Bye.
Thank you.
Okay.
Bye-bye, everyone.
Thank you, Chair.
Thank you, thank you, thank you.
Bye-bye, everyone.
Thank
Bye.
you, Nigeria. Thank you.
Yeah, thank you so much.
Thank you all. Thank you all.
Bye, everyone. Thank you.
Bye. Bye. I say hello to our brothers and sisters in all those different parts of Africa. Thank you.
Tunashukuru sana
Okay, hao ni wenzangu sasa.
kutoka Tanzania.
Ah,
Tuko hapa pia.
Tanzania. Oh, I'm so
Yes,
sorry I
bwana
didn't
Usaji,
recognize you.
niko hapa.
Jirani.
Nimekuwa pamoja na nyinyi na tunashukuru sana. Semina nzuri sana.
Asante sana, twashukuru pia mmeshikana mkono na sisi.
Tumetoka Zambia
Hii
sisi.
ndio Zambia. Oh my goodness. Okay. Oh, that's wonderful. This has been wonderful to have all of you with us.
Thank you. The chief arbitrator.
Thank you. Thank you, thank you, thank you. Okay, so Madam CEO, feel free to end the webinar anytime now.
Thank you.